so with enough on our plate already, we'll go ahead and move into your presentation, your discussion, Dr. Fletcher.
Okay. First, I want to thank the people that are here to observe our conversation, for remaining here and being here to be able to hear board discussion on this topic. So very briefly, the reason I originally brought this up to put on our agenda, I want to make sure I clarify, because I don't want that to get away from the discussion, is that my perception in talking to stakeholders as well as the forensic community is that we have a problem. And the problem is that we are seeing child custody evaluators leave that role and not accepting further appointments. We are seeing people who are great candidates to provide that service for the protection of the public saying, no way, Jose, I don't want to complicate my life or put my license at risk. And I'm hearing judges as well as attorneys in conferences as well as in hallways at conferences talk about how hard it is to find someone who's not conflicted out, who is capable and trained and experienced to do child custody evaluations. Judges and attorneys are the ones who talk very openly about this because part of their job is to, as we all know, is an attorney's job is to advocate for their client, and the attorney's job is to vet or make sure that the people who are involved in the case that are professionals in our profession do a good job. And so the list is getting shorter and shorter in every community. I've been asked, as someone who does provide that service, to do child custody evaluations in other communities, not because I'm special, but because they've gone through the list and there's no one else left on the list. So that adds to the cost when you bring somebody from out of town. It also it costs the litigant more because we're having this problem because they go back to hearings. So the problem as I see it is we don't have a good succession plan in order to have qualified child custody evaluators who are available and willing to accept an appointment by a judge to provide this service. And I believe that is something that goes to protecting the public, and that's one of the reasons I asked for this to be on the agenda. As we know, that has stirred up a number of things, and I would like to add that I want to continue to focus on the fact that we have a scope of our role on the board, and all the board members know that. We would love to change the world. I'd really like to change the system. I have some complaints about the litigation system also, as we all do from our experiences. But our scope is to look at how we protect the public, and I believe that there are two pieces to that worthy of our discussion, which we began at the last board meeting. And one of them is how do our rules and our complaint process, how effective is that in making sure that the bad ones are held accountable and that the good ones who meet all the criteria and don't break any board rules and do a good job with the experience and all aren't scared away by the complaint process. Are we balancing both, knowing our role as a board is to protect the public? So I brought it to the board to begin discussion to look at. The complaint process, first of all, there are complaints that are investigated and found that the original complaint was not something that says that the person broke a board rule. In fact, I was smiling, and I apologize, I can't always mask that. But today, and I won't go through what the case was, but as we were going through some of what we were going through today, there was one in there that there was a complaint that somebody said somebody made lost their children because of a psychologist doing an evaluation. I've seen that before, and what I am questioning, which we're not going to talk about specific cases, is if the litigant, so the mother or father, was confused, possibly, which is possible when you're in an emotional state and you don't have a law degree or a psychology degree, that when a judge made a ruling and possession or parenting time was changed or primary parent was changed, they may have believed that the psychologist had something to do with it. Sometimes those are psychological evaluations that are not child custody evaluations, but based on that, a judge may rule a change in parenting time. So that's one thing that we know occurs, and those in the professional community are aware of. The other thing is that there are checks and balances. So as we're looking at this problem, we already have a lot of things in place that are outside the scope of the board in order to address whether or not a child custody evaluation should be admitted. And we don't determine that, a judge does. So I won't go into a whole lot of that unless you all have questions, but there are checks and balances. There are times that I serve as a rebuttal, and you heard some of the public comments today where other people do the same thing, where a custody evaluation is submitted, and then one side doesn't like the outcome. They hire another person with the experience and training to be able to look at that and guide them to know what the holes are, what the gaps are, if they didn't follow the Texas Family Code, and possibly if they interfered with board rules. As someone that plays that role, I also look at the LPC rules, because I'm not an LPC, I'm a licensed psychologist, it's a different board, and that's one of the questions I'm going to assist the attorneys to answer. But then, that is part of my job in the role. So we know there's checks and balances already. We know there's a Texas Family Code. After the last meeting, I sent it to you all. I expect you read every single word of that. No, I don't. What I wanted to show you is there are essential elements that have to be done. And we do a great job of it in Texas compared to other states. And I used to do these in the late 1990s when they were called social studies. And I want to go back and redo them because now we have better criteria in terms of the Texas Family Code of what's expected. We didn't have that before, and you heard Dr. Flynn in his public comment talk about he's done over 1,000, and in the early days, they were done a little differently. The Texas Family Code, I think, does a great job of talking about expectations. That's out of the scope of what the board does. So when we look at the problem, we're running out of evaluators. Other people, there are people who are not good, and they're not under our license. Okay, they're not part of what we are here to regulate. We're here to regulate psychologists. So as we look at our complaint process, I'd like to put a couple things in perspective, if I may. Again, referring to Dr. Flynn, because he obviously was prepared, as we would expect anyone with a PhD and a law degree, and his level of experience in this. He talked about the statistics related to divorce, and there is actually a chart that I did not give to you all, because we have enough paper already, but I thought I could tell you this is from published information, this is from a study, and it talks about 50% of divorces are uncontested. Those are the ones we don't hear about because people do a good job of addressing it and move on. That's a high percentage. About 30% are settled but not uncontested. We won't give all the examples of that, but that also, I think, is what we would hope for many people, correct? 11% are settled with mediation. In the state of Texas, mediation does occur prior to a trial. And I know as someone who does these evaluations, I do everything I can humanly possible, as do many of my colleagues, to make sure at mediation we've already submitted our report as is expected by our order. So they have that as a frame of reference to know. Sometimes it's not possible, and it's a limitation not of the evaluator, in my humble opinion, but of other factors. 5% settle after the evaluation. 2% settle during trial. 1.5% the judge decides. So that's a little bit, but there's something different about that population, which I think you heard public comments today, and I won't address those, but I think we've all heard a number of different theories about that. So it's 1.5% are judge decided, and I think it's important to reiterate they are judge decided. I want everyone to know that I am very willing, as many of my colleagues are, to say I will make recommendations that are not followed by a judge. And that's the way it should be. The judge decides, the evaluator doesn't decide. So as we look at our complaint process, and as we look at that there's a problem with our succession plan, and I agree with Dr. Harvey, who said as a new evaluator, people were saying, why are you doing this? Are you nuts? Are you crazy? I have to watch that I don't say that to people, and hopefully, Dr. Harvey, I've never said that to you, because I will question. I want to know, okay, you've heard all the bad stuff. Why do you want to do this? I'm not going to do that anymore, because I'm going to support and encourage anyone who wants to do this. So much so that I just completed supervising someone, because as our board rules say, if you have a license and you're ABEP, you do 3 under supervision. I just did that. I want you all to know it's a huge commitment. It's also my license, and I don't do that small. I take that very, very seriously, as I would expect everyone who supervises to do. And there are many people who are not willing to do it, similar to people who are not willing to come for a weekend to assist with oral exams, you know. So I want to make sure that the board has a very healthy, honest discussion about protecting the public, but also recognizing that our rules and our complaint process, clearly we want to make sure if people have done something wrong and broken a rule, that we catch them and we have that information. But we also want to be aware that there are a lot of people who don't do this work because of the fear of the board. We are scary, apparently, and the complaint process is scary, and people talk very openly about how long it takes for things to be dealt with, and that you have to hire an attorney. So there are a number of solutions, first of all, that have been proposed, and I would like to have a conversation at the board level about that. One of the things I want to address as we begin that discussion is there was a letter that was given to us, and I see the person that provided this isn't here, and you know, I'm disappointed in that, but I still would like to address it. It's by a person whose name is Shelby Michaels, and we've heard her name before as someone who is a professional. She's an LPCS, which means she's taken some additional training to be a supervisor at the LPC level. I've looked up her information. I even have a copy of her CV. I requested that separate from this whole process, because her name does come up a lot. And in the second paragraph of the letter that was provided to us, which is written by Ms. Michaels, it says, I regularly conduct both clinical and ethical reviews and consultations for attorneys filing malpractice lawsuits, private clients, malpractice insurance companies, private foster agencies, occasionally directly for state agencies. She's conducted reviews of LPCs, LMFT, social workers, and psychologists located in the state of Texas, as well as many other states, many of them large. So I just want to speak to this for a second, because this is concerning to me, and I just want to make sure everybody's aware. This person doesn't do child custody evaluations. I looked to see what literature has been written by her about custody evaluations. And I think we have to be careful about people who have opinions, professionals as well as lay people, about the work, because I want to know, do they have the knowledge base in order to state those opinions? And I want to be really clear, this is not in a courtroom, this is in the community. I would have concerns about someone who doesn't have the training and experience weighing in on opinions and the damage that can do. John Gould's name has also been used a lot. It was used last time, it was used again today. So after the last board meeting, I called Dr. Gould. I have his cell number. He's licensed in the state of Texas. I've consulted on cases with him. He wrote the book, The Art and Science of Child Custody Evaluation. If you look up his name, I think it was pronounced Gould last time, it's Gould. He's published many works. He assists boards. I will be with him next Monday, Tuesday, and Wednesday in Texas for some training where we're both on the faculty for that. So I called him and I just asked him a few questions. And I asked him as an expert who does this. And I asked him about his experience in other states and had a very healthy discussion. And asked him, what is the solution to this? He was very willing to come and give 3 minutes. And because he's going to be in Texas our live Sunday. And that wasn't something that was able to be done, and I also don't know that in 3 minutes we could have tapped into his wisdom or any other expert at the national level. Here's what I'm hearing. I know that for the complaint process, we don't want to do anything for anybody making a complaint that causes them to spend a lot of money, have to have a level of expertise necessarily that they don't have. We want to be sensitive to that for somebody making a complaint, because we're not saying we don't want the complaints, but I think we need to look at our process. And so that's one of the things I would offer to the board that we need to consider. I think that, and that's one of the things Dr. Gould and I talked about at length, because I think that's a good point. We also need to look at the data, whether it supports the trend of the complaint or the actual complaint. And I think that if we have a discussion about the possibility of somebody making a complaint having higher level of responsibility, and we can talk about what those can be in a second. I think that also might be something for to have conversation. I'm very aware, and from talking to Dr. Gould, David Martindale, Saul Rappaport, a number of other people who do this literature, that there are people making complaints during litigation as a way to stop litigation or make the person biased. It's something that I know has happened to my colleagues, and if I'm a court-appointed therapist, especially when alienation is part of the issue, if somebody makes a complaint, I'm off. And if people want me off, that's the best thing for them to do. And it's happening to colleagues a lot. They're getting savvy that that's one of the ways to say, she's biased, and you would be because you're trying to defend yourself. So it's used for that purpose. I think we need to address that, and there are some ways that we can. But the opinion that is provided, the conclusions and the recommendations by the child custody evaluator, is presented to the attorneys in a written report. It may or may not be submitted to the court, thanks to the current Texas Family Code, which in the beginning I didn't like that part of it, but now I'm starting to really enjoy that. And I am, because what it does is it gives people options. And I think anytime we can provide a good child custody evaluation with data to support opinions, conclusions, and recommendations, a healthy discussion among the attorneys and their clients, as well as possibly in a courtroom, may possibly occur. So we've talked about the problem, we've talked about the complaint process, we're talking about the importance of data, we're talking about the importance of recognizing whether somebody's doing it as a litigation strategy. We talked about what percentage we're looking at. Thankfully, I tucked away the last yearly report in some of the materials I bring to each meeting, and in 2014, fiscal year 2014, when it's related to child custody, as I read this correctly, there were 13 that were dismissed, but doesn't necessarily mean there were 13 complaints that month, because we understand how time goes on. Fiscal year 2015, 23 were dismissed. 2016, 14, 2017, 9, 2018, 5. And I just want to say in 2018, it looks like there were no complaints made at all based on this. There's 0 in every category. So I want to make sure.
2000 and what?
I'm gonna hand this to you for you to speak to give the data, but I want to overview, just say that many of these complaints are dismissed for a variety of reasons. Because the complaint as it comes in, and which is why I asked for Alfonso to stay here if we have any questions, the board has any questions. So I'd like to open it up for discussion and then talk about what's our next step, because I do think that, and I appreciate all the public comments, everybody's opinions, and I even appreciate when I hear them outside of here when they're done appropriately, because I do think we need to address this, and I do think we need to talk about, is there room to make some changes to what we do with our complaint process, leading towards these being investigated?
I have a question. And it speaks, I think, to the bottom line of differentiating between, do you have an actual problem with an evaluator, or is this a litigation tactic, or is it sour grapes, or somewhere in there? When the board's obviously heard an outcry, and some of the things that I have heard described as the methodology of how the evaluator went to make an opinion, form an opinion on what's happening within this family that's breaking apart without talking to parents. I've never been in the evaluator's shoes. Can you speak to
I can.
What qualifies as a behavior that qualifies as negligence or dereliction of duty versus somebody who's making something up?
So I'll be brief, and I'll be happy to answer that. I think you talked about sour grapes, problem with the psychologist, and then I think emotionally fueled complaint,
Right.
because it's out of the court system now, the decision's made, the gavels come down, and they're angry, and they're looking at their other opportunities to try to deal with what they perceive to be a problem. So I understand that. My first question in the public comments last time as well as this time, which we are not able to ask, is when somebody comes in here and they say they never even interviewed me, my very first question would be, was it really a child custody evaluation, or was it a court-ordered psychological evaluation where you're only going to evaluate one person, and it's one piece that's provided to the judge, which I provide that, psychologists provide that when they're ordered and they accept an appointment to just do a psychological evaluation. At that point in time, you may collect collateral data, which may be in written form, or an interview on the phone, but you may not meet. I don't meet with people face-to-face that are collaterals in that, because I'm just evaluating mom or I'm evaluating dad. I'm answering the court's questions. And based on that, sometimes a judge may make a ruling about parenting time and possession and access. And so my first question always is, okay, that's a clue to me that it's possible it wasn't a child custody evaluation, because the Texas Family Code requires that you interview both parties to the suit seeking possession. In person. Yeah,
So
I mean, I can look at it, yeah, I think it's in person,
So
yeah.
if it's an actual child custody eval, the psychologist must talk to both.
Those essential elements are written in the court order, as well as what's been provided to you after the last board meeting. So collaterals, sometimes it says a joint meeting with both parties, which I promise you I don't do at the first appointment, but I do it later. I want to know what I'm dealing with first and provide safety. It talks about the importance of many of the elements that you have to interview the child the age of 4 and up. You have to interview the child in a forensic interview. Yippee, that should be done. It holds people accountable to do that. So it says a balanced interview process. So,
And in fact, Dr. Fletcher, if a complaint has been made to our board and an ISC panel hears that it's a child custody evaluation and that everybody wasn't interviewed, I guarantee you the case is not going to be dismissed.
That's important to have that here on the record, because when you have the outcry that we've heard, that's the standard. If that actually happened, like I'm pissed.
Yeah, it sounds horrible.
Yeah,
and it is.
And that's
Yeah,
something
if
for
that's what
the protection of
they're
the
doing.
public. That I'm glad we got that out.
yes, and I want to offer too, though, if an evaluator goes to court or submits a report where they didn't meet the essential elements, I promise you, I've been on the stand from 9 to 5:30 in one case where somebody didn't like the results and my recommendations, and they tried to discredit me. And it was not discredited because I followed the essential elements. I serve in a role where I point out if essential elements aren't done, and you know what happens? It gets thrown out. The judge never sees it. It is never considered. So there's already a check and balance system in the court system if somebody doesn't do the essential elements. Judges don't, it doesn't get entered because you didn't follow the family code.
Would you see those evaluations that are not custody evaluations but psychological evaluations that may ultimately, by the judge's determination, get objected to in the same way?
I can't say that they would get objected to in the same way, but they get scrutinized and you get cross-examination on it. If you use an old test, which we all know that those are things that get you in trouble. I think that there may be, part of my answer to you is there may be a perception by a litigant possibly that because a psychologist did a psychological evaluation, even though they did not you cannot make recommendations about possession and access if you haven't done a child custody evaluation. So in a psychological evaluation, you do not make possession access recommendations. The only person that can do that is the one that's done it, as we know, a child custody evaluation. But I think the litigant may perceive because a psychologist did an eval on one person, submitted it to the court, which is what our duty is in being appointed. It's considered and reviewed and considered, and then the judge makes a ruling because it's part of a custody case. They may see the psychologist's psych eval as being the reason for that when actually the psych eval is only in a small scope of service. That's why I have questions when people say they never even interviewed me.
Well, and I don't know if you and I were on the same ISC panel, but there was a case once where somebody it was not a custody eval ordered. It was, I think, some other sort of psychological evaluation, but either the psychologist, I forget, I think it was a psychologist, went right up to the line of. Were you on that?
We were on that.
Okay, so the point is that it went right up to the line of. They didn't officially make an actual recommendation, but boy, you didn't have to even read between the lines to know the opinion there. That wasn't asked for. Not everybody was consulted, and it had a. I think it was shown that it had an impact on the outcome, and we didn't. I don't know what happened, but we didn't just let it go.
Right.
Because that's
That
the
would be
stuff we're trying.
appropriate,
Right. That's the stuff
To
we're
not
trying to
let it
protect
go.
against.
Right.
And we've had numerous cases like that.
Right.
Right.
And that's
And they're seen in the
not
courts
unusual.
all the time too. They never even get to us.
Right.
Because it's not submitted or relied on for an outcome in that case. I'm in a courtroom sometimes observing because I'm allowed to stay in if I'm an expert to hear testimony, and some therapist is testifying, LPC, licensed psychologist, social work, is testifying, and they will make possession access recommendations without doing child custody evaluation. It gives me hives when that happens because you're not allowed to do that, and yet I don't have to do anything about it because the court does something with it. They get thrown off the case, and then typically a new person is appointed to work with the children. Usually that's what it is. So I want to add that there are rules about making recommendations for possession and access, and clearly if there is an ISC and it gets to that point where somebody did just a psych eval and they made possession access recommendations, it should be in our arena. We should be dealing with that. But there's other arenas that deal with it too.
Right.
Do you know there's so many things that we've kind of talked about that could be done, and so many of them are complicated and questionable. And we don't want to discourage complaints.
Absolutely we don't.
And so, the one thing that keeps coming, I think, through to me is that question of, is the case still pending, is one of the easiest things that we could do that could have a tremendous impact. That we need to change it so that it's not a litigation tool.
Mm-hmm.
And that in order to make a complaint, there has to be that order, presented, signed by the judge, that it's been decided.
So the question is, was it relied on for a decision to be made? And there are times, I'm guessing, just from my view, that it wasn't. But I don't know. And
And that may determine whether somebody wants to make a complaint or not. And some complaints may have been filed, and then the person turned out to get what they wanted, and then it's a very different situation.
So what that means is, part of the process when complaints are made, we need to ask a few questions. So is the case still pending? Was there a jury trial, determination by a judge or by agreement of parties being brought to the court for finalization? How and when was the appointment of the evaluator made? Were there any other evaluators? If so, what was their opinion and basis of their opinion? Was there any legal objection made to the report being filed and entered into evidence? So in other words, was testimony even offered? What do you believe constitutes a violation of statutory requirements of child custody evaluations or the board rules of practice, and has another expert reviewed the report in question? And I'm going to tell you, many times another expert has reviewed the report in question. And that data may be available. So I think we have to look at what the data says rather than the accusations, because it's an emotionally filled situation for families who have gone through this process.
Has anyone seen the complaint form that they use in Arizona?
It's online.
I have, yeah, I've seen it. It's actually called a claim form.
Uh-huh.
Did you have one?
I have one right here. Yes, sir.
Yeah.
Dr.
Pass
Mock,
it
would you
around.
like to see it?
I would like to see it.
So in Arizona, for the purpose of the board, and we've all looked around because we're not the only ones with this problem in Texas. They have a process where a claim is filed, so they have like a 2-tier process, and then whether or not it turns into a complaint. You want to speak to the judge role of it because you've investigated some of it.
Yeah, the way it works in Arizona is when you submit a claim, it goes to staff look at it and make sure it has all the requisite information that's required in the claim. If it does, if it has sufficient information and supporting documentation, they then farm it out to 3 of their board members independently. It's a blind review. No, those board members don't know, really who the other board members are that are reviewing it, and they work independent of each other. They don't talk. And I think the way it then works is all 3 have to agree that there is a rule violation here. They send it back to staff, send the report back to staff. They all three have to agree before it can go on, be moved up to a complaint status.
And they're all independently evaluating it
Yes,
separately without any collusion.
correct.
Right. So it's like a blind study.
The problem with that is, you guys can't be involved at the investigation level.
We're not usually involved in the, well, I guess does the ISC count as investigation, or?
No, there's a statutory requirement for an ISC. But if you remember, we had an enforcement committee that would have kind of served this function. It probably would have fit real nice in here. But Sunset did not like the enforcement committee. They want y'all treated more as judges, not as investigators.
We don't do much investigating or really any to
Right.
speak of now. Anyways.
You know, this form, I mean, it asks the questions that Dr. Fletcher was saying we needed to ask. And it makes a lot of sense to me, and it doesn't seem to me that it provides any unusual barriers to someone making a complaint. It just gives us more information so that we can evaluate.
But you're also talking about making it a requirement to wait before you can even file that form
Right.
until the litigation has been finalized.
Right.
And also to determine whether or not it's been used for decisions to be made as it relates to possession and access.
Well, but I'm not sure that they would know the answer to that question.
The person making the complaint?
Yeah. I mean, that's more in the judge's head.
Well, so let me clarify, if it's never entered into the record,
Okay.
then the judge has
I've
never
seen
seen
it.
it.
Okay, so that would be the question, not, I wouldn't say whether it's used, but was it entered into the record? And I
Right.
think that that's in that form.
Right.
Yeah.
And I wanna be fair, if you're a litigant, you don't always understand, like, when I ask questions as an evaluator and I'm asking, has there been a hearing set that determines what you're gonna do temporarily? They kinda look at me, but there was a temporary hearing and I actually have the outcome right in front of me, cause it's just language they're not
Oh,
used
okay.
to.
Yeah.
So sometimes they're not the best one to provide that information, but the documents they can provide can give us that information. And with the family code now, it goes where I submit my report to the attorneys and a notice to the judge that says, hey, I'm done, it's been given to the attorneys in more formal language. So the judge doesn't even see it because that's the opportunity, you know, the statistics I was talking about, for there to possibly be a settlement without a trial. And so, in mediation. So part of what I do think that it's important that we know what stage the case is in,
Mhm.
whether a report has even been filed, and how that report may have been used in litigation. And those are not hard questions to answer. It's just sometimes the person making the complaint, I'm not going to say that they're not honest. I think sometimes people can be dishonest. But I also do think that the questions we ask, the information they give, they may perceive it as correct, and we just need to get verification of that. So one of the options is that any complaint involving someone who's done a child custody evaluation, possibly the other litigant who is a party to the suit, needs to also be interviewed or as a collateral in the early stages of the investigation, because they may be more motivated to provide the data and make sure that, and it would be verified, that they didn't just write an affidavit.
And this form asks
Yeah.
for who the other litigant is.
And it's possible someone may say, I don't know where he is, I don't have a phone number, he's never told me where he lives, or whatever. But I do think there needs to be some guidelines. So if this is something the Rules Committee, again, Dr. Palomares may enjoy the opportunity to review, so that we can move forward to consider what we're discussing and possibly proposed rules pertaining to the process. I wanted to ask you if you could, because you and I had a conversation, because Arizona also requires for people to go back to the judge if they're dissatisfied.
They used to.
Right.
Yeah, they did away with that.
And they did away with that because?
The judges hated it. The judges don't want that. And one of the things y'all asked me to do after the last meeting was go visit with some judges, because I told you, you're never going to get a judge to come in here and talk in an open meeting about this stuff. So I went and sat down with some, and I asked them point blank, would y'all serve as the gatekeeper? And it wasn't no, but heck no.
They said
not.
heck no?
No.
Yeah.
No way, no shape do they want that back. I had a pretty candid conversation with them, and one of the things they did mention was, in all honesty, this agency is better equipped to judge, a lot of times the appropriateness of the evaluation than what they are. But at the same time, they also recognize the kind of the crisis level, or what's going on, the abuse of the system. They certainly see it.
Did they have a comment about the lack of, or the difficulty of finding evaluators?
Yeah, I mean, candidly, it is tough. I mean, because they recognize that everybody gets grieved when you're in this. I mean, I'm not going to say who the judges were, but they get grieved. I mean, when these people go nuclear, it's anybody that was in the room, and they're grieving and filing complaints on everybody. So the judges were like, even we're having to deal with it.
So we also received letters in advance in our board packets from attorneys, and I'm hoping that all of you have read that and seen what the attorneys are saying. There were 6 letters that were submitted prior to, that are in our board packets prior to us coming here today, and some of them were from family law people. 2, it looks like, were psychologists, and then 4 were family law people in the state of Texas talking about their concerns as we look at the complaint process. And I would want the rules committee to make sure that's considered also, because I think they bring a perspective of, we see the importance of this, and in many cases may need this, and we get good data. But I know there are people in this room that they have a wait list of a year before they'll begin, and you get people that will say, okay, we'll wait. Okay, I'm just going to tell you, I'll go out on a limb and say that's not best for families. That people wait a year before a child custody evaluation begins, and then it may take some time. There have been concerns about cost. We've heard about how much all this costs. I want to be really clear, and I think Dr. Tinder did a good job. I believe it was her that said 30 hours of video is submitted. I want you to know, as an evaluator, no matter what we're doing, I have an LSSP working in the schools. For whatever purpose I'm doing an evaluation, I used to do pre-employment for fire and police, and I'm going to tell you, anything that's submitted to me, I'm going to review to determine whether or not it's relevant for what the question is I'm to answer by my evaluation. When somebody gives 30 hours of tape from a nanny cam, and they say, you've got to see this, and it's the attorney, not the litigant many times, we want you to review this. You're going to review it, and that's 30 hours.
Whole week's work.
And my children wonder what I'm looking at sometimes. And I've been given screenshots, I've been given porn, I've been given lots of things because it's relevant. Don't tell my mother. And so we're not seeking it because we want to do 30 hours looking at nanny cams. Many times we will explain in a very professional manner, this will be 30 hours and look at my hourly rate, and it would make sense that I would have your client pay 100% of that. Would you like to talk to your client about maybe showing me exactly what you want me to look at, or do you want me to proceed? Because they don't think of it, they're just trying to try their case. So we're not looking for this to be, I'm just going to tell you, that's not a great way to make a living, is looking at 30 hours of tape, and it's a small piece. But if any piece of data is provided to me, I'm expected to look at it. I've been involved in a case that I had one sheet of paper among probably 3,000 that had an inventory and it had guns on it. And I asked each litigant separately, this document was provided to me, I want to ask you about this inventory. And they're like, he has guns? And she said, she has guns? I said, I don't know. This has been provided to me and I'm asking the question. Come to find out, the attorney's office accidentally put that page in. And it was from another case. It had nothing to do with the case I was involved in. And they were shocked that I looked at it. Well, of course I looked at it. You gave it to me. And so I was trying to determine the relevance. So, that is part of it too. And also collaterals. Collaterals are so important. The literature supports that. So we're going to interview people, and they're not just going to be family members. We're going to interview people who can speak to the parent functioning and the emotional health. And sometimes there is going to be a number of them. And I promise you, I'm not on the phone for an hour with a teacher, even though a teacher wants to spend that time because they feel very passionate for the best interest of the child. I'm looking at parent functioning. I'm looking at how it affects the child. I'm looking at the data that I need in order to answer the court's questions. I'm invested in the process, not what the outcome is. I want to make sure that's really clear. I'm going to follow a process, in order to give opinions, conclusions, and recommendations, but the judge determines the actual decision-making regarding parenting. They just take my recommendations, and guess what? They don't always do as I say. And I think that's a beautiful thing.
I would add one thing about the fees, and I know we've heard some comments on that. I was going to say point blankly, I would stay away from thinking about any kind of regulation on fees. You get into that marketplace, manipulation of the marketplace there. So separate and apart from the political climate of doing that, you could trip into some kind of an antitrust or some kind of market manipulation type area there. So I'd stay away from that. Let the marketplace regulate that, or let those guys over in the pink house regulate that if they want to.
I think it's really important that people understand how much work doing these evaluations, how much work it is. But there's another part that I think people don't understand, and that is how much work goes into looking at these complaints. And that I can't tell you how many times people have said, you can't just dismiss it. Well, it's not just dismissing it. It gets dismissed after it's been thoroughly investigated and been looked at by numerous professionals. And so the process involved is very arduous. And it isn't, whether we suggest some disciplinary action or we suggest a dismissal, that an equal amount of work goes into that, trying to figure out what is the right thing to do to protect the public.
2 lawyers have looked at it, and 1 investigator has looked at it if it's dismissed at the staff level. If not, then I got 3 board members who have also looked at it at that point. So, yeah, you're right. There's a lot of work, and these are very intensive cases.
But from the public perspective, we can confidently say it's been looked at. From the psychologist's perspective, that doesn't solve our problem. The problem is that there are complaints that have to get reported to insurance, which are driving people out of the industry. So, I guess identifying that part of the problem. I mean, the Arizona solution seems pretty great as a safety valve to receive the complaint, but they call it a claim.
Yeah,
They receive the information. They receive the fact that we're going to now begin this investigative process, and now it's got to pass muster to get to that complaint level that would get reported to insurance and everything else. I don't know if we do a mirror process, but somehow we've got to have a safety valve in our intake of the complaint.
When you say a safety valve, say what you mean.
I mean, it's got to pass. It's got to meet. Well, it's like an indictment. You've got to pass a certain level. You don't have to necessarily prove them guilty right there.
Ugh, okay.
But you understand?
I know, sorry.
You pass
Exactly.
you've passed a certain threshold of a burden of proof that
Yeah.
says this is substantiated. There's something here that definitely needs to go all the way.
Before the psychologist is made aware of the complaint and has to start contacting
Sure.
Yeah,
Yeah.
because I think if we
Yes.
have more that occurs before the psychologist is even contacted, I think that I'm hoping there's some consideration of that. Because once that psychologist is contacted, and Dr. Tinder last meeting talked about, after she stopped crying, she called her malpractice and then called her attorney. And I think that's the experience many psychologists have, and I appreciate her vulnerability with that, because there's a lot that the stakeholder is responsible for at that point, and they're going to do it, as they should. And yet we got a letter from Ben Albritton, Dr. Albritton, in our last board packet that talked about that as he does what is expected by a stakeholder when they are alerted that there is a complaint, that at this point in time he is running into difficulties with insurance and his malpractice insurance. And so they're not asking, well, how many complaints were dismissed? It's a complaint.
Right.
So they see him as a risk. Every forensic person is a risk.
But that's it. Here's the flip side of this, though, is if we get a claim or whatever that hasn't yet reached that bar, but if we get something incoming that says, here's the court order that ordered the custody evaluation, and they didn't talk to everybody. I mean, that's boom. We're talking about
But if it says it was a
something.
psychological evaluation.
Exactly.
It's
That's
different.
a different story.
Yeah.
That's a misunderstanding from the public, which that's another problem that we should probably not ignore, but.
Right, or a misrepresentation of the public.
Yes.
And I don't,
I mean, here's the thing, so many of them say they didn't talk to everybody that come in. Correct me if I'm wrong, but I mean, I'd say the vast majority accuse
Very
the
common.
psychologist. So almost all, if that's a speedway to proceeding on, you haven't really solved anything, because most of them are gonna go right through that filter.
Well, except when we
Can
have a
we-
report, we see if they've talked to everybody or not.
or the court order appointing the professional. That will determine whether it was really a child custody evaluation or a psych eval. And even people that have just had psych evals later, I've heard them in court talk about when a custody evaluation was done, and I know it was a psych eval. I may not have been the one to do it, but they misrepresent that. And I'm gonna tell you, I don't know that they're doing it purposefully in a devious way. It's just language they don't
Different
understand.
language, yeah.
And
Terms
I
of
wanna,
art.
yeah, and I think that, but we need to vet, or, we need to clarify. That's why we're talking claim and complaint. I think there's a clarification process that needs to occur to know what are we dealing with, and we need other sources of the data rather than just the person making the complaint. Not because we're not gonna listen to them, but we've gotta see the data to back it up. Data has to back this up. And I think if we increase the responsibility on the person making the complaint to provide the data, we're going to be more efficient with our staff attending to these, because that's one of the complaints we're hearing from the public is, the gentleman with the camera was saying it's taken 2 years. Okay, well, I can appreciate his frustration, but I also know all the variables that add to that. So if we can be efficient with the staff's attention on very important complaints, and we have a process in place so that it's really clear based on the data about what the next step is, and it's dismissed before all this other stuff happens, because there's a reason to dismiss it. They haven't done something that's broken a rule. Or there was a misunderstanding, it was a psych eval, not a child custody evaluation. Litigants, in my opinion, see those two things as the same thing when they're involved in a custody dispute. And you know what, I understand it.
And when it goes wrong, though, we've seen psychologists, though, treat them almost like the same thing, and then we have to talk about it here.
Yes.
Been the therapist and never testified, didn't produce a report, and been told that because of me they lost their children. Well, I won't go into that, but and I get it, because they're upset. I get that. I think all of us in here see the visceral reaction or the emotionality of all of this, and we understand it. But our role and the scope of our role is to look and see whether or not a stakeholder has done anything against the rules that are expected. If they don't talk about the limitations of their testing in their reports, okay, that's easy. I'll point to it. Okay, you needed to have done that. We saw a number of those today. Okay, and I'm not looking for easy. I don't like to use that word in tough jobs like this, but efficient, because I do think that we need to be efficient. I think the governor would appreciate that with our resources and have a process in place. So would it be appropriate to ask the Rules Committee to take all this data and suggestions and then come up with some proposed rules to present at the next board meeting for consideration?
Whether proposed rules or policy, perhaps, or making a distinction between what might be done. Is that a reasonable way to?
Yeah, and here's the distinction. If you're creating if you want to set a criteria that staff have to follow when evaluating a complaint, in other words, you're telling us, y'all need to be looking for these things when a complaint comes in to see if it's valid, you can do that via policy.
Okay.
If you're wanting to hold the complainants and the licensees to something, a standard for them, then that needs to be in rule format, because they're not bound by our policies. That policies are really directed at us, the staff, how we do things.
So I have a question. Looking at what's been provided to us that Arizona uses, I don't know what's more efficient for the staff. That's why I appreciate you being here. Is that when there is the initial phone call and there is gathering of information, my guess is you have something in front of you where you're gathering certain things. Would we take what Arizona has and incorporate that, which would be policy?
I think you would want that rules, because you would
Yeah.
want
Okay.
the complainant bound. You want them
Okay.
required to submit that, and if they didn't submit it, they're out.
Correct.
The complaint
Right.
would
Just
be
like if they don't
denied.
show up to the ISC, we can't interview
Right,
them.
right. So I think that really needs to be in a rule format.
So perhaps, let me ask this, in a more general way. I think specifically we're concerned with custody related as whether it's custody evaluation or whether it is psychological evaluation performed in the context of the custody matter. Essentially, that pretty well probably accounts for court-involved cases. Now, this may muddy the waters a little bit, but I think in terms of talking about policy or rules, we need to think about some other contexts that come up, particularly with court-involved cases that may be therapy cases, or maybe we need to look at, maybe we need to separate those out. But I would say that the investigation process, which is really what we're talking about here, is probably should be pretty similar. So I would like to see it framed a little broader, more in terms of court-involved
Rather than
complaints.
just focused on custody. Yeah. I'll say, I genuinely think that you can do the requirement that they, much like we did with the LSSPs and requiring them to wait until they've gone through the due process hearings. I think you can wait and tell people, you gotta wait until your trial's over, the hearing, you got a final order. I don't think there's any problem with that. We'll have to tweak that so that they wouldn't run afoul. We heard a complaint, I guess it was yesterday, that thing had stretched out like 5 years or something. We want to make sure that we weren't putting people in a catch-22 where they had to wait until the rule of limitations had already expired for their complaint and cheat them that way. But we can do that.
Is there any consideration given for appeals if it's going through the appeal process, or is
Well,
it like after the first ruling?
I think I mentioned that in my notes here that I gave to y'all. Technically, an order doesn't become final until the last appeal is exhausted, or until your deadline is final. But I don't know.
Can't wait for that.
I don't know why we'd wait for that. That might be 10, 15, it might be. It'll be a long time.
At least the first.
At least the trial.
Yeah.
You've been through the final trial court hearing, and you got a final trial court judgment entered. Then you can file the complaint, I think. And I think it needs to be a hard bar. If that's not done, you cannot file the complaint. And part of that reason being is, just from the lawyer's perspective, like what you said, there are a lot of gatekeeping functions built into the system already.
I promise you.
I'm going to file a Daubert motion on you. I'm going to try to strike you as either unqualified. I'm going to go after
Send
your
a
opinion as
rebuttal,
being
expert.
unreliable,
Mhm.
and then maybe as even being unnecessary. But if one of the things I've talked with some other government lawyers about, because really struggling what to do here, and they said they weren't cautioning me as in they weren't threatening us as in saying y'all better not do it, but one of the things they were saying you need to be thinking about before you start investigating and possibly sanctioning people for opinions or reports that were admitted into evidence is think about the dichotomy that sets up. You got a judge that has said, we got a qualified expert, we got a reliable opinion, I let it in, it's in evidence, and now here you come, the board later on, and you're saying, no, you're not qualified, and it's not a good opinion. Where does that leave your licensee? They're caught in limbo there.
Mm-hmm.
That's the same reason we did what we did with the LSSPs, is we didn't want that. We didn't want the opportunity for a contradiction there. So basically what the lawyers I was talking to were saying is be very careful whenever you start second-guessing trial courts. That's why we pay them, but at the same time, I've got, I'm just candidly speaking, those judges are like, honestly, y'all know more about this than we do. I don't know. Glad I don't have to vote on it. Y'all do.
In looking at this claim form, or not claim form,
Yeah.
It's claim
the
form.
report form, it's case specific. They've already said this is an unusual, this is not like other complaints. Now, they may have a different complaint form for each type of complaint, but this one here, it's only for this, and it's like they've already established that this is weird, this is strange, this is gonna give us a headache, and so we're gonna do this. So if we were to say that a complaint or a complaint on a child custody has to be handled differently, maybe.
I agree. I think the best way would be to develop a complaint form specific to whether it's child custody stuff or we expand it out for forensics in
I'd
general.
like consideration for expanding it out, because the cases that involve parental alienation where somebody's appointed to do reunification therapy we're going to have more and more where we're going to be dealing with complaints related to that. And there are a lot of people that are not willing to do reunification therapy because, let's just face it, you're hated, and it's tough work, and you really do need to consult with colleagues, know the literature, because it's totally different. And so I think if we expanded it a little bit and allowed for the specific questions related to an eval, I think that would be ideal for consideration.
A second point, and let me just go ahead and throw in some doom, at least from my point of view. There's a service delivery gap being created by people not wanting to do this kind of work. There's going to be zealous individuals, because if they know your bill was $47,000 or something, I guarantee you're going to start seeing people come into this business that are not able to do it. Like you were saying, you want qualified, you want people that are qualified. Can you all see if there's nobody to do it? Well, hell, Antonio will do it. He needs to buy a boat or something, you know. I don't know how we can stop that other than just you're going to see more complaints because people get into it that shouldn't be in there. You could have.
So I'll speak to that, because our board rules already say if you are going to do a child custody evaluation, even if you're already a licensed psychologist, you have to be supervised for your first 3.
Okay.
And I'm going to be honest with you, a lot of people aren't even willing to do that. So they pull themselves out of it because they don't want to be supervised to do 3. If you're not a licensed psychologist, it's 10. So there's things already in our board rules that stop just any individual who thinks they might want to kind of do it, and their buddy asked them to. They're not qualified until they've been supervised to do 3. So Sandy, who is the person I just supervised, went to graduate school together. And so she's not a newbie. She's had very good leadership positions and worked in a school and other things. And she wouldn't appreciate it if I kept identifying her. But I will tell you, it's a great example. This far in her career, she was supervised by me, that we went to graduate school together, for 3 of them, because that's what the board requires. And she knew she didn't know what she didn't know, and that forensics was different. And she went to national conferences. And so she isn't going to make money for probably the first 2 years because of the amount of investment that's required. In our board rules, it says you have to have a certain amount of hours of training. There's a lot of things already in place to stop just someone we kind of like who might want to do it, who wants a boat, which I get that, totally get that. That those things are already there, and those are good things. And I think 3 is good, and anyone that does the 3, the people who are really good in the long term, they don't stop at 3, even though that's what the board requires. I just paid David Martindale some pretty good money to assist me on a case because it was so high profile. That's what we should do as professionals, is make sure that we continue to know what we're doing and get the training and knowledge and consultation. So that's already in there.
I think
for 3.
Our rules and the 107 of the Family Code, it's designed to kind of keep like the roofing scams, people that come in real quick and don't know what they're doing.
Big truck.
Yeah. It's
Or the
designed to keep that
yeah.
undesirables out. So if that breaks down, we got bigger problems than this.
I think that's already been accounted for, and that's in our board rules, I think, do a nice job of that.
Yeah.
And we just sanctioned someone who was doing that, and they're reimbursing the client for all the fees as well as paying additional fees and restricted license supervised practice for 3 years. So when it happens, I think the board came down appropriately, but could be seen as a harsh punishment.
That's an appropriate complaint.
Yeah.
And that's a good example of what the ISC did in response.
And in fact, the
Because they
board
broke a board
does,
rule.
when we see broken rules, we do something about it.
Yeah.
So kind of getting a feel for some of this since I'm on the rules committee. Are you seeing court-involved cases or court-involved assessments or court-ordered assessments? Do you see it as broad as any court-involved cases, not just custody? Are you looking at it custody, or are you seeing it as the larger, where it's court mandated assessments, or broader than that, just any court-involved case? What are
I have a
your
question.
thoughts?
What does the data show about complaints on people that are court involved, like outside of family law too?
You're talking about, we break it down into general forensic and then child custody. General forensic will represent anywhere from, 15 to 25% of the total forensic cases that we receive. So the child custody make up they don't make up, the majority of the forensic cases, but they're the most difficult to deal with out
I
of all
think that's the problem we're
forensics.
trying to solve.
The general forensic stuff, in all honesty, it's not nearly as difficult
Okay.
to deal with.
So that would be
It's
the
easier to find
answer to
professional
consider.
reviewers for you
Yeah.
than
It
it
is
is.
child custody
Yeah.
that we're talking about.
And I would say evaluations, because I want to make sure I'm clear about psychological evaluations that are court ordered. And you know what, let me just tell you, many times what I observe is judges know that the litigants can't afford a child custody evaluation, or they don't want to wait till that whole process goes on, or that process is so difficult. So a judge may say, as a way to kind of be least restrictive, let's just do, the concern is about this parent, and here is what I need some questions answered, so could we have a psychologist do a court-appointed psychological evaluation, and that may be enough. And I love those, I do, because I'm providing information to the court to make decisions, but I don't know a lot of the other stuff because I don't have to, it's not in the scope of my role for the question I'm to answer. And how does this person's functioning possibly, according to the literature, could it possibly impair their parent functioning? But I don't answer the question about access and decision making.
If you saw something, let's say the court asks for a psychological evaluation or some whatever evaluation below a child custody evaluation, you see something sketchy, you see something that it leads you to, in your professional opinion, that needs more investigation. Could you or would you go back to the court and say, hey, judge?
It's a great question, and here's the answer. It's part of my recommendations. I had one that I did that I felt she needed a neuropsych. And I had an IQ on her. I knew where her daily functioning had impaired somewhat suddenly, no head injury, asked all the questions, asked the spouse. And so that is part of the responsibility when you do a psychological evaluation. You make recommendations. So sometimes it might be a medication management recommendation, or it might be a recommendation for a neuropsych. It's a great example because that has come up. But you don't make a recommendation for supervised visitation because that has to do with possession and access, because I haven't met the children. I don't know, I don't have the data to support that recommendation.
Even if you saw something that might lead you to sort of think that maybe.
I'm going to say I have concerns about their functioning and judgment, and you don't have to take a yellow highlighter to a judge when you say those things.
They can make the leap on their own.
That's what they're looking for, and then they go. Because I can't make, if I see, so your point about sketchy, if I think somebody's being sexually inappropriate, or there's something that was disclosed to me, it is highlighted in my report and what the things to consider as it relates to parent functioning.
And then would you make a recommendation for further investigation of
Yes.
this thing? Okay.
Yes.
You can recommend that a child custody evaluation be done.
Yes.
Yeah.
Yes.
I thought I've seen that before.
Yep.
That's a key distinction too. I mean, if we had an incoming complaint or claim, again, if a child custody eval was not ordered by the court, sorry, we don't have a whole lot to discuss here in terms of a complaint.
We see that a lot. People complain that it's a child custody evaluation, and we get it in, and I'm like, this court order says a psych eval, dad or mom.
But it's still a complaint that you still got to ring everybody up to even dismiss, correct?
Yeah.
And that's the problem.
So, and that's brings me back to the original reason I wanted on the agenda, is because I think that we want to have an efficient complaint process that catches the bad eggs and is able to have the data. We know what data we're looking for to be able to tell the difference between a bad and a good egg. And so I don't know that our process is as efficient as it can be in the early stages before the stakeholder is alerted that somebody has filed a complaint. And that's what I'm asking for, and it sounds like Dr. Palomares, it's gonna be on your plate in that rules committee again for consideration, because what does that sound like, and what would it look like as a possible rule to be proposed and discussed?
Do y'all have any concern? I mean, one of the things that when I listen to the public comments, and there's an outcry, I think, for an opportunity to be heard in the complaint process. Statutorily, we're required to give them that opportunity at the informal settlement conference. What we're talking about here is creating a mechanism to sort out those complaints that really should never make it to the ISC. And I guess what I'm kind of worried about, right or wrong, what I'm kind of worried about is people feeling like we cheated them out of an opportunity to at least be heard. Can you think of, I mean, if we beef up the intake on the complaint requirements, do you think that would satisfy that want for greater input into the complaint?
We would find out, but I certainly do believe if the complaint comes in and then we give them tasks and they complete those tasks, that they realize they've given us a lot of information. They've had a role in, lifting the hood a little. I have concerns, and I will say that this board meetings are not forums to complain about one psychologist.
Right. You're right.
And it concerns me because we have rules that need to be followed for stakeholders as well as for public meetings, and when I see rules aren't obeyed, and then the complaint is somebody didn't obey a rule, I'm gonna look back and say, okay, are our rules pretty clear? Well, our rules are pretty clear, but when people feel emotional, I don't know that we would ever satisfy somebody making a complaint if we gave them a microphone, 2 days, they could have private meetings with us, meet with each person 2 days in advance and buy us lunch, I think that it's a process people are in when they're unhappy with their life circumstances, and some of it feels out of their control, which I understand. That I don't know that they're ever going to feel as if they've been heard thoroughly, but if we have a process that guides them what we need and they're actively doing that, I don't know that that's a bad thing.
Again, my thought, if they can show how a rule has been violated, boy, I'm ready to fast track it to deal with it. But again, the board, you kind of already said this, the board of the complaint process is not time to just go to war with somebody who didn't give you the outcome you wanted, which is sad. And we're dealing with one of the worst situations in terms of the demise of a family. Our role is to get it right if it is a child custody eval. And that's
the scope of what we're asked to do, and that's protect the public.
Right, and again, the complaint from everybody complaining about this is child custody evals. They're not complaining about psych evals. Maybe they are, they're not, but
I think they
See,
are.
and that's a question that I have, is if we look at only the child custody evaluations, and so someone fills out that form and says, no, this wasn't a child custody, it was a psychological evaluation. Does that complaint then automatically get filed against the psychologist, and does it go through that process? And so it goes in that direction rather than waiting for the court hearing or whatever we're looking at the final court hearing. We're gonna if it's a child custody evaluation, I think one of the key things I heard is that one of the criteria is that they've had to have the final court hearing. Then
the ruling has to occur.
The ruling has to occur. and I think that's appropriate. I'm in support of that. But if it's not a child custody evaluation, then do we move them into the current process, which means we automatically investigate and a complaint goes forward and goes on their record because it was just a psychological evaluation?
Why don't we refer to the
point.
situation rather than the type of evaluation?
Okay.
So that if a child custody question is involved, it goes through this process. Then it wouldn't matter whether it was
Okay.
psychological
Yeah.
evaluation.
And was a rule broken?
Yeah.
Or
So-
are they unhappy with the outcome?
So it's the context
Yeah.
of the complaint. If the
If
context
the question is involving child custody.
And I think that goes back to the court-involved cases in general, that you've got to look at how this fits into the litigation,
Yeah.
and where it is in the process. So I think that the context needs to be broadened.
That makes a lot of sense to me, particularly because we've found that they don't always understand that it's a psychological rather than a child custody or,
Mhm.
yeah.
And I think we have to anticipate that and account for that so that we get the data that's important.
Do you know, this probably is not realistic, just in terms of kind of the format, but I'm even imagining that part of what this form could do, the claim form, is to provide some education as well. So that, for example, if you're asking for the court, for the court order, so that you know exactly what is ordered, then you could even have in parentheses, a psychological evaluation is different from a child custody evaluation and has different requirements. You know, something like that allows people to be told ahead of time, this is part of what we're looking at.
I think we're gonna have to have a copy of whatever the report was to be able to look at it, and a copy of the order to determine all of that
Right.
ultimately.
Right.
But I don't know what we do with the information if they're still jumbled in what they think was ordered. But I think ultimately we're answering those questions on that form. Or we aren't.
So-
Alfonso, you are.
So let's say that they wait till the litigation is concluded, the trial is concluded, and we create kind of a separate pathway for complaints for forensic, which is really what we're talking about here. We create this second pathway, and they submit a copy of the court order, a copy of the report, and their allegations is, well, Ron Palomares he only contacted one of my collaterals, but he contacted all 32 of my ex-wives. I guess, how, what are your expectations at that point for staff at the investigation level?
Are you gonna look at the report and see what actually happened?
Did they break a board rule?
No, I mean, not that I know of.
Or did they violate a statutory requirement?
There's no requirement that you contact every collateral.
Right.
But it says something to bias, and the report
It's
would
about
help you to
balance.
determine.
Yeah, it's about balance. If mom provided 20 collaterals and they're all the kids, dentists, orthodontists, all of that, you gotta be careful, because 20 from mom, 4 from dad. The 20 are because mom, has a Rolodex and hands you all the, so there's so many factors to that when you're looking at balanced. If mom gave 20 neighbors and all her social friends and people she's in touch with on social media that she hasn't seen in 10 years, and dad gave 4 that are, people that have gone on vacation with them. Okay, so there's so many factors, and I don't know that that's the staff's responsibility.
Those are judgment. It's where
Exactly.
I'm going.
Yeah.
That's a judgment call, and I don't know that
Not a numbers
we can make
comparison.
that.
I don't think you should. I don't know that it breaks the board rule. I think that is dealt with already in the Texas Family Code, rebuttals. It's in the arena with the attorneys and the judge.
Okay, yeah, it goes back to.
Because I get asked those questions on the stand all the time. How come you didn't talk to this person because she saw him vaping in the parking lot of the school? Okay, but every other bit of knowledge that collateral has is from the mother. She's never even been with the dad.
Yeah.
So it's a clinical judgment that we are expected to use, or forensic judgment. So to back up, I think part of it is that a lot of questions can be answered very early on if the staff, the investigator has a copy of the court order, the original order appointing the person, and a copy of the report where you see that no access and possession recommendations were actually made, or a copy of the final order or mediated settlement agreement.
Yeah. And I think we would need to know how the court treated it. Did they strike the expert? Did they admit it? If they admitted it, I guess that makes our job pretty easy at that point, because that's the judge finding you're qualified under the family code and under the board rules, and your opinion is reliable and it's relevant.
And there are ways to know that.
And just because another expert comes in and disagrees with you doesn't necessarily mean you violated the.
Can I just say, there's always another expert that comes in and disagrees
I
with
know,
you.
and that's one of the things I was going to point out is, there were some comments made about, well, we've had all these other experts. There must be something there if you receive this number of complaints and this number of experts. And I'm like, if it constitutes a rule violation every time another, counter rebuttal party comes in, I'm like, that means either Susan is wrong every time she gets on the stand and somebody questions her, or they're wrong if you're questioning
And many
them.
times,
I'm like, that'll never
litigants don't
end.
know who else is behind the scene. They don't. They don't know that the person may be behind the scene, even though they're paying the bill.
Yeah.
They're not
Okay.
discoverable. So I think that what we want to look at, the goal is to be efficient, to be fair, to look at board rules, to recognize that there are people that have been through this process who feel like they've been wronged and they're mad. Yet our scope is pretty well defined. We protect the public, and we have rules, and if a rule is not followed, that's where we can do something about it. And I want to be really clear that I take very seriously, as I know everyone at this table does, when our stakeholders are saying, I'm not going to perform a service because of the way I'm afraid of the board, I'm afraid of the complaint process, I don't want to complain, I'm a single mom and my salary, supports my 4 children, I'm not going to do that work, it's too risky. Okay, that is true, but if we're contributing to that because our complaint process is so burdensome, and I think Dr. Albritton's letter is really important, and I hope people go back and read it from the last board meeting, because he is someone that we have data to support. His malpractice insurance is affected by complaints, even when they're dismissed, because he's doing what any professional is expected to do. He's letting his malpractice insurance know, and he's securing an attorney, which is the responsible thing to do. And I won't say anything else about that, but I know that because a lot of people say, why do they get an attorney? They should just fight it themselves.
No.
So that discussion doesn't have to. But that's my concern. I am trying to recruit colleagues to do this work, and I'm having great difficulty, as are a lot of other professionals who have shown up today's meeting. We are very willing to support them, but they understandably feel as if the fear of a board complaint, even though it's ultimately dismissed, is going to interfere with their abilities.
I guess I'm curious to see how the public members, are y'all, what y'all's thoughts about this is, because you're.
We're looking at you, Ryan.
I know. I'm listening, and I mean.
It's a lot to process.
Yeah, it's a lot to process. Give me a few days.
My bottom line is that the public, we have a problem. I think part of it is an education and perception problem of what the services that they're getting from the psychologist and what it's supposed to be. But I don't think that's the whole problem. I absolutely recognize the problem with the disincentive to do this. If anyone wants to understand how I think, read Freakonomics, because when you look at strange incentive structures, you get bad outcomes often, and I think that there's some whacked out disincentive structures here that when you're talking about the complaint process, it's a bad incentive structure to where if somebody has, and I get it, with a parent backed into a corner fighting for their marriage is down the drain, now they're fighting for the kids. And if I was in their shoes, I'd throw everything at it too. Everything I got to do whatever I needed to do to keep the kids. And if that means discrediting whoever's saying or suggesting that maybe I'm not fit to have my kids, well, what can I do? I can file a complaint, you got it. Blast it off. And I recognize that problem. That said, a lot of the things that I've heard described in from the public, if those things are true in the context of a child custody eval, we have some discipline to do. So.
Many are dismissed, and they're dismissed for a reason.
Right.
They didn't break a board rule, or what they initially said in their complaint, the data didn't support.
And that's where that where's the threshold of going from investigating something that could be wrong to bumping it to the
So
full-fledged
you can't ignore
complaint?
that.
I
Most
get
of them
it.
are dismissed. I want to add to, and it isn't our responsibility as the TSBEP board, but now that we have, are we saying BHEC? Is that how this goes? Is that how we're going to?
No, we've been saying it for
I'll
the
get
past
on
4
board with
years.
that, so I'll say BHEC. That sounds like a bad word, you know, so I'll work on it. Is that, you know, the LPC board, some of you may know that they send it back to the judge. And we have discussed a bit why we think that is not going to hold up, to say it that way. But I do think that we have an opportunity with the executive council now into play and soon, because if we can get some really good things in place, maybe that'll assist other people who are licensed in doing this work, who are not psychologists, because it's an issue for LPCs, people with social work. And so that to me is about putting the children in Texas and families in Texas first and protecting the public. But our responsibility is to our stakeholders and to the public. But I want you all to realize this is just a really great time to be having this conversation because of some of the changes that are occurring. And if other boards can learn from us and benefit from what we do, that helps children in Texas. So I just think that's an important consideration. And the timing of all this is relevant.
And with that being said, and you all have taken voluminous notes, and
No, sir. Dr. Palomares has
I have all the confidence in the world that the Rules Committee will have very healthy and robust discussion and have something that.
A draft.
keeping in mind the sorting out of whether it is a rule versus a
Policy.
Mhm.
Yeah.
So, any other business that needs to be taken up? I don't believe so. Any
discussion.
other issues that need to be brought up? With that being said, then it is 2:39 p.m. and this meeting is adjourned.
Thank you.
Thank you. Do you want this, Bob?
I can